This is Don Frederico, host of Higher Callings. When a person becomes a lawyer, they take an oath. The oath is often administered in a formal bar admission ceremony. Each year in Massachusetts, many such ceremonies take place at historic Faneuil Hall. The new lawyers and their families hear speeches from judges and bar leaders, and the oath they are required to recite dates back to colonial times. Through it, they pledge to do no falsehood, nor consent to the doing of any in court, not to participate in the pursuit of any false, groundless, or unlawful claims, and to conduct themselves in the office of an attorney with the courts according to the best of their knowledge and discretion, faithful to the courts as well as to their clients. Most states' attorney oaths also include a commitment to support that state's constitution and the Constitution of the United States of America. These promises new attorneys make are lifelong commitments. They are promises to abide by the rule of law and are vitally important to the strength of our democracy. And they are only the first, but also the most fundamental, of the professional duties lawyers assume in exchange for the privilege of practicing law. One person who takes the lawyer's oath most seriously is Scott Harshbarger. Scott has practiced law in Massachusetts for more than 50 years. He has also held high office, including serving as the district attorney for the largest county in the Commonwealth in the 1980s and as the two-term Attorney General of Massachusetts in the 1990s. In 2019, Scott co-founded a nonprofit organization called Lawyers Defending American Democracy, and he continues to chair LDAD's board. Among other activities, LDAD seeks to hold lawyers accountable when they violate their professional oaths in ways that threaten to undermine democracy and the rule of law. I recently spoke with Scott about his early influences, his decision to become a lawyer, and his career-long commitment to professionalism, as reflected in the oath that lawyers take. Those topics are covered in the first portion of our conversation. At approximately the 56-minute mark, we turn to a discussion of the mission and work of LDAD. Throughout our entire conversation, I never tired of hearing Scott's perspective of the role of the lawyer in defending our democracy and the work his organization is doing to protect the rule of law. The following episode is our complete conversation. I encourage you to listen to it in its entirety, even if you need to do it in more than one sitting, as Scott's inspiring description of his early influences at the beginning of the episode helps to place his values and ideals into an illuminating historical context and demonstrates the roots of his commitment to the work of LDAD that he describes later. And please consider sharing the episode with your friends, family, and other contacts. I'm with Scott Harshbarger. Scott needs no introduction for a lot of listeners, I think, but I will introduce him in a minute. Scott, how are you today?
Good, thank you, Don. It's a pleasure to be on and nice to talk to you.
It's great to talk to you. I've been familiar with you from a distance for a long, long time, ever since you were district attorney of Middlesex County in Massachusetts, and I was a young lawyer just getting started in my career. It's great to have you on the podcast and actually to spend time with you and get to know you a little bit in a way that I never have before. So thank you for appearing. And let me just say, we're going to talk about democracy and about the rule of law and about the organization that you co-founded and chair, Lawyers Defending American Democracy. But before we do that, I thought it would be important for us to talk about your background, who you are, what your influences have been over the years, and do it in a way so that people can know a little bit about you, especially people who don't remember those days when you were in Middlesex County and when you were Attorney General of Massachusetts. So, Scott, why don't you start and just tell us about a little bit, briefly, about your childhood and some of the influences you had growing up.
Well, thank you. I spent over 60 years in Boston and Massachusetts, but since I had not born there, I was always treated as where you're really from. And I was from central Pennsylvania. I grew up near State College in Ferguson Township outside Pine Grove Mills. My father was a minister, first at the Church of the Brethren and then chaplain at Penn State. My mother was a teacher, both the first in their family to go to college. But it was central Pennsylvania. That's where I went to State College High School and played sports. Grew up. Those are my influences. My cousins were all farmers, and that was the era. And I realized at my age, I have lived through the death of the family farm. I mean, every cousin of mine and my parents themselves grew up on farms and in central Pennsylvania. But now all that area is really taken over by Penn State University, which is the farms have died. The steel mills in Tyrone, other places are gone. So I was from central Pennsylvania.
And you were a PK. You were what's called a PK, a preacher's
kid, and that was tough right from the beginning. But basically, I also, because I was a preacher's kid, my dad had gone after his career as a Church of the Brethren pastor, had gone to Yale Divinity School. And so he hoped that I could go to the Ivy League. And I ended up at Harvard College as a result in the fall of 1960. That was the first year that the Pittsburgh Pirates, after a decade, had won the pennant and were there. And there was also the election of John F. Kennedy in 1960. Yep. So that was that class at Harvard. And that's how I got to Harvard. I played football. I ended up graduating in 1964. And my final football game was, I was practicing for the Harvard-Yale game in November 22nd, 1963, when John Kennedy was assassinated. And so it was a tragic period of time, but it was also the awakening of sort of a new era. But so that's my background. But my influences clearly were in many respects, my father and mother, and because of their background as farm kids, as members of the Church of the Brethren, which was one of the first pacifist churches, along with the Quakers, and sort of a liberal branch of the Mennonites, but a very important part of my background, as well as the opportunity to be at State College, which was at Penn State and at a much different era than many other smaller communities.
Yeah. So you went to Harvard College. Do you know when you were an undergraduate that you were going to go on into law?
No, I don't. I didn't really think about that at the time. At the end of my senior year in college, actually my senior year, I got married. And it was one of those times where everybody's looked back and said, "My, you're very young to be married." Of course we were. But many of my friends at that time simply got married a year later after they graduated. But we had graduated, and therefore I was not technically eligible for the various travel scholarships that might have existed, not just the Rhodes Scholarship, but others. But the Rockefeller Fellowship was one that offered a year at a theological seminary. And particularly for those who never really planned to be ministers. It was a trial year fellowship. And I applied for the Rockefeller Fellowship and got that fellowship and spent the next year at Union Theological Seminary in New York City, which was the year of the Harlem riots. That summer, it was, to me, not a life-changing, but a year that pulled together so many influences about what I would do and what had done. And probably when I first began to think about going to law school was in that year.
So who were some of your influences at Union?
Well, the great thing about Union at the time was it still was in its heyday. It's one of the few non-denominational seminaries, and at a time when seminaries were still very vital. And as you know now, many of the seminaries have simply not been able to continue. Non-denominational, even denominational ones, except for some of the evangelical churches. But at the time, Union was still in its heyday, and Reinhold Niebuhr, Roger Shin, major theologians and scholars were there. And I had heard about them from my father, obviously, and some of them actually had come to speak at Penn State, because that was the era when those college chaplains, college campuses were very, very imbued with speakers. It was before the prayer in schools decision, so that state universities and college chaplaincies were really quite dramatic. And Martin Luther King had spoken at Penn State, Reinhold Niebuhr, Richard Niebuhr, Sam Proctor, and many other well-known folks. And so that Union was a big hit to there. But one of the keys for me was you're required to do field work. And I had never thought about doing field work in churches, in the suburban churches I was connected with. It just didn't seem overly relevant. Well, this was in East Harlem. I went to Chambers Memorial Baptist Church, a minister named Mel Schoonover. But I also got to meet William Stringfellow, who was a lawyer, who was with the East Harlem Protestant Parish. And it was a quite dramatic year of observing the church as a powerful social gospel force in the community, an activist, but also one that sort of providing services, not simply standing back and commenting.
Was this the sort of at the very beginning of the social gospel movement in the Protestant churches?
I think so. Looking back on that, it was actually a model on the Catholic urban ministry, which had been very active in the late 50s. But the East Harlem Protestant Parish was really the first significant Protestant social gospel effort in urban communities, and it became the model for many others. But at the time, it was also blending sort of the push for civil rights and equality, using the church as a vehicle for a very important, not just messages, but impact in terms of housing, working with gangs, the whole range. And it was just it turned out to be a very enlightening experience to see how you could blend the social gospel with real activism and really try to make a difference in the quality of people's lives.
You know, you preceded me a little bit. I'm a few years younger than you, but not that much. So I was not quite politically aware at that time, although I think I was becoming politically aware. But at the time you were at Union, I mean, that was a very transitional period for our country. You mentioned JFK's assassination, which I think triggered some of that, and then the civil rights movement. So you were there at a really keenly interesting time. And you mentioned Bill Stringfellow.
Yeah.
I won't go into this, but just for listeners, he was a lawyer. He graduated from Harvard Law School, as you ultimately did, and he went to work in East Harlem after law school to help people there who needed legal assistance and couldn't afford it. And I actually had the privilege of meeting him in the early 1970s when I was in college. And I also spoke recently with another lawyer who you know and whom I only recently met, who also went to Union Theological Seminary and also was influenced by Stringfellow. So I just wanted to kind of mention that. I might want to do a podcast someday about Stringfellow because he was such an interesting character.
Well, and his book, actually, the book My People is the Enemy, was a very powerful treatise calling upon all of us, particularly the Caucasian community, to stand up and deliver and understand what the impact was on poor people and people of color, and along with Crisis in Black and White by Charles Silberman. And that really was, and you may not recall, but that was the Vietnam War was beginning to develop and grow at that time. So you were having that confluence of things along with the civil rights movement and upheavals that were occurring in the cities.
So how did all of that, the beginning of the anti-war movement as Vietnam was beginning to escalate, the civil rights movement as it continued to progress, what you were exposed to at Union Theological Seminary. How did all of that influence your decision to become a lawyer?
Well, that influenced it because, first of all, you were looking, as a minister, you were looking for doctors or lawyers to help deal with specific issues. That was one side. The second was, my father was then beginning, maybe he was becoming somewhat disaffected or skeptical, but it became his view that many of the institutions that heretofore had guided our moral perspective, the churches, educational institutions, were losing their impact. And he believed that, for better or for worse, the law was becoming the way that people would define right and wrong, good and evil, and that the law would be the vehicle for dealing with these issues over the next generation, just as the ministry had been, he felt, for him. And so law school became, for him, the way to prepare yourself for whatever it might turn out to be. But the law was going to be a pivotal force in dealing with social, moral, economic, and other issues in our country. That was his perspective. And it was one of those times where he turned out to be totally right. And so law school became a vehicle. When I got into Harvard Law School and had a chance to be there, the goal was to use the law to become a vehicle for the social gospel, if you will. But that was going to be the way that you dealt with the kinds of issues we were beginning to be very exposed to through my year in East Harlem, and of course reinforcing what my parents had been not so subtly drilling into me from the time that I was a young boy.
So you went to Harvard Law School. When you're a first-year student, of course, there's all sorts of required courses. You probably didn't have electives at that time in first year. Most schools don't, and or at least not many. But then, what was your focus? What were you thinking of doing while you were in law school? What were you thinking your next step would be after you graduated?
Well, that was interesting. At first, my first push there was to become active in the Harvard Voluntary Defenders. I ended up being the president of the Harvard Voluntary Defenders, which was a student organization that, because of the rules in Massachusetts, the so-called 311 rule, students in the third year, under the supervision of attorneys, could handle cases in the district courts of Massachusetts, criminal cases. And at the same time, in a parallel way, the legal services movement was building for civil cases. But I was very taken with being a criminal defense attorney. That was, at the time, it seemed to me, that was where the law, the power, sort of intersection of power and law played itself out, and you were representing people who without you had no one. And at the time when we were as students, of course, it was first grade experience. The second piece was you also came to realize that many of the people that we were representing were, yes, had committed crimes, but they were there as much because of social and economic factors as otherwise, that you weren't getting bankers and corporate fraud and that kind of thing. It was sort of minor crimes, and that was long before the major impact of guns, of that kind of violence was playing so much, and even the awareness of domestic violence, so that it was much more routine, people getting caught up because of their economic and social circumstances in the criminal justice system, and the public defenders were really the vehicle by which their rights were being asserted. And guess what? That was being asserted because the Constitution, the Sixth Amendment, protected them and gave them the right to counsel. And that was the same period where the Supreme Court at the time, the so-called Warren Court, produced Miranda and all the other important First Amendment, Fifth Amendment, Sixth Amendment rights of citizens under the Constitution of the United States.
The 1960s were an amazing time for a lot of reasons, but especially in the law as well as politics. With that Warren Court, there were all these important advancements in rights of accused citizens. And you were also dealing with all of the you were living through some of the civil rights issues as you worked in East Harlem for that year. And of course, the anti-war movement and the Vietnam War affected all young men who were draft age. You were maybe a little beyond draft age when you were in seminary and law school. I don't remember how it worked in the 1960s.
Well, it was just pure luck in one sense. I was, first of all, the first year I was married, and therefore there was the Kennedy exemption for married people. Then we had a son born in my commencement day era in '64, and therefore I had the dependent exemption. Now, but many of my classmates and people thereafter were really getting concerned, because then the draft came, and that triggered a whole other anti-war movement, which wasn't quite based on moral conviction as much as it was we don't want to serve. But you were really what you're pointing out is that was the time when there's a whole collection of forces. The Supreme Court was asserting that the Constitution and the rule of law, even in tough times, mattered. Even the tough, even criminals deserved to be represented. But people of color who were being discriminated against were entitled to have equality. And so equal protection, due process, fairness were drummed into any of us in law school, even though, as you point out, it was not a modern era of teaching civil rights or anything else. I mean, you were drumming through accounting and commercial transactions and all of that. But you were seeing on the outside, you were seeing how the law was being used by leaders in the legal profession as a tool for fundamental reforms and equal justice protections. And that was very influential to me, because only because it was the right thing to do, but because it built on my experience of having been in East Harlem. And so you could sort of relate to why this mattered to people on the ground, not just academic people. And then Boston became, of course, the source for desegregation and major issues in the North.
Right. So it's interesting the way you just described your influences and how you were influenced by all of these events, because the values that you developed during that portion of your life obviously have carried throughout the rest of your life. I could jump right now to talk about lawyers defending American democracy. And I think it's obvious to anybody listening to this that your values that you've really formed and understood in the 1960s are still what are driving you today. But I'm not going to jump. I think we'll talk a little bit more about your background. Did you go straight into the public defender's office?
No, interestingly, at that point, like anybody else, I got the lure of the big firms. And the big firms at that time were in Boston. They were the so-called Big 12 had 20. They were called the Big 12 if they had 25 lawyers or more. And so, much different era. And so I went to Goodwin, Procter and Hoare. I'd spent a summer there. They were it was a great law firm, but that's sort of where you went. If you didn't go to legal services, which was sort of available, that was sort of the opportunity. I went, but it was a time when the law firms were, if not actively leading the charge to support the rule of law, they were very willing to have partners and associates who identified with protecting the rule of law. And my influence at that point was to see the leaders, the willingness of the heads of Goodwin, Procter and Hoare, Foley, Hoag and Elliott, Hale and Dorr, Mintz Levin, be willing to lead the charge, to allow associates to actively engage in civil rights work, but more importantly, to themselves stand up, oppose the Vietnam War, stand up for civil rights with the Lawyers Committee for Civil Rights under law. The John Gardner created Common Cause at the time. And And what you saw was the lawyers standing up. I now look back on it as a profession. We're not just business people with clients. We have a special obligation and opportunity to try to reform the law, protect, uphold court orders, stand in the face of the political attacks. And it was the legal profession's responsibility to uphold the rule of law, regardless of party, regardless of the political forces. And it didn't happen overnight, but over a period of 5 or 6 years, culminating with the Saturday Night Massacre with Archibald Cox and the Justice Department, where the legal profession, the American Bar Association, the Boston Bar Association, all, in my mind, stood tall in standing up for the rule of law and the Constitution. Whether you agreed with busing or not, their point was the federal court has ordered it, it's been upheld, it must be enforced. The law must be enforced regardless of the political passion or the impact. And that shaped my view that the legal profession could have a very significant role in preserving law and order, if you will, as well as upholding the Constitution and protecting and defending. And it was our job, because these folks were making a lot of money. They were representing corporations, but these partners in law firms were were actually actively themselves participating, but also encouraging and allowing associates to do it, not to change the law firms around, but basically because they felt it was the responsibility of the legal profession to uphold the constraints that keep us free.
Right. It's a privilege to be able to practice law, and it's a privilege that's only bestowed on those people who have met all of the requirements and gone through the education and all of that to be a member of the bar and to practice law. Part of what comes with that, you believe, and I think a lot of lawyers believe, including me, comes a responsibility to make sure that the law is being applied fairly and equitably, which often means it means a number of things. But one thing is making sure that people who cannot afford legal services are getting the legal services they need.
It's an oath. It's an oath. Let's not kid ourselves. It's not just that the ABA, the rules of the professional responsibility talk about aspirationally what we should do to uphold the law and preserve it. You take an oath of office, and this is what public officials do too. You take an oath of office to uphold the Constitution and laws of the Commonwealth. And that is what has been so, in my mood, to fast forward, so viciously undermined and corrupted by the current situation, that people who took an oath of office to uphold the Constitution feel that politically, for partisan reasons or whatever reasons, they can ignore that responsibility, either sit on the sidelines passively and do nothing, or even actively further efforts to undermine that. And I don't mean to jump ahead of that, but at the time, that was a pretty important part of why lawyers justified standing up to President Nixon. It wasn't just used because we took an oath. It said, that's our oath. That's our responsibility as lawyers, is to uphold against all attacks, partisan and otherwise, the rule of law. That's what impressed me as a young attorney, because we were trying to reform the law. But here was in some examples of the leaders of the law also being understanding this is what the role of the lawyer is in today's society.
So you saw that playing out in the Department of Justice during Watergate, which is, you mentioned the Saturday Night Massacre. That's what that was all about. We saw it playing, I wasn't in Boston yet, but you saw it playing out on the streets of Boston with the desegregation litigation, which was before Judge Garrity, federal judge in the District of Massachusetts. Very controversial at the time. And he was a hero, I think, for many, and a villain for those who
Right.
opposed
Yes.
the desegregation orders. But all of these things were happening. You were observing them happening. You ultimately, as I understand it, you spent some time in the public defender's office, which would be
Right.
kind of a natural extension of the volunteer lawyer's work you were doing at Harvard. But also, you then, at some point, ran for district attorney of Middlesex County, which people who don't live in Massachusetts may not know. I think it's the largest county in Massachusetts.
It's larger than 13 states, 1.4 million people, 54 cities and towns. I did have a couple mentors that did influence how I looked at this, because I had been a lawyer, but I was determined to be a law reformer. Couldn't imagine being a prosecutor as opposed to a defender. And we went to the public defender's office and actually effected a number of changes, including recruiting a number of talented people, all of whom became judges, became prosecutors later on in Massachusetts. I was then offered the opportunity to become chief of the Public Protection Bureau in the Attorney General's office when then Frank Bellotti had been elected Attorney General. He had run several times for office, had not been successful. Frank Bellotti opposed busing. I was selected to be chief of the Public Protection Bureau, which was to be the major social justice arm of the office, he said. And the question was, would we support the court order? And Bellotti's position was that we would if I could prove that was the law. But people demanded my resignation from him, and they picketed his office because they said, you ran against busing. You won because you opposed busing, Frank. By a small percentage point, you won, and we supported you. And he said, yes, that's correct. That was political. He said, but I'm the Attorney General. If you tell me that Harshbarger was wrong on the law, I'll fire him in a minute. But if he is right on the law, then we will uphold the law, because that's the role of the Attorney General. I'm not a Democratic Attorney General, Republican Attorney General. I'm the Attorney General of the Commonwealth. And so for me, as a young lawyer, a reformer, seeing in fact, a person who was the quintessential political person in Massachusetts, the partisan activist, stand up and say, independently of my own personal views or my political background, the law is what matters when you're Attorney General, when you're upholding the law. Then that to me was, more than 2,000, any number of books you could have written. That was a guy who risked his political future to stand up for the rule of law. And because of that, he became the most popular, you may remember, Attorney General.
I do remember.
In the state and the country. He could have continued as Attorney General for his entire life, because the decisions we'll make decisions on the facts and the law, not partisanship or politics. And that's how we'll represent people who without us have no one. That was that example to me has always been particularly important. I like to think I'd have done it anyway, but I had an example of somebody who actually did this.
It takes courage, and especially during those very fraught times in connection with that particular case. There was violence. There were threats of violence. I don't know whether threats of violence were directed at him, but I imagine they were. It comes back to what you said about you take an oath, and you have to have the courage to abide by the oath. And it's the same kind of courage we saw, and I do remember this. I was old enough to remember the Saturday Night Massacre.
Right.
Same kind of thing, only that was in the White House, and it was White House counsel or Department of Justice lawyers, attorneys general. So it's the same thing. And it's the difference between being a principled-based public servant and somebody who doesn't care about principle and just wants to achieve a political goal.
But what that proved was that you could, as a reformer, you could go into the government and become a vehicle for reform, and almost more effectively. And I noticed that this is the thing that quietly Kamala Harris talks about. and because it varied, people's view at the time was, "Are you kidding me? You can't go from be a public defender and go and work for a prosecutor." But at the time in Massachusetts, because of people like Frank Bellotti, a lot of the public defenders had been full-time practicing attorneys, became first assistant district attorneys because they were full-time practitioners. And then we hired all the good young lawyers to come in, and it became a vehicle for major reform within the law. The Attorney General's office in Massachusetts became a vehicle for major reform on a number of issues then, and continues to be at this point. And so when running for office, thinking of running for office in district attorney, it became a possibility. The biggest downside wasn't that I had been a public defender and then a prosecutor. It was that my name was Harshbarger in Massachusetts, and there aren't many Pennsylvania Germans or Pennsylvania Dutch. And it was sort of like, from then on in my career, it was sort of like 50% of the people supported me because I wasn't from Massachusetts. Another 50% never trusted me because I was not from Massachusetts. So it was, it became a vehicle that is, for me, it was an opportunity to take what I had learned and to become the leader in a major office. And if you could see if you could replicate what was being done in the Attorney General's office at the time. So it was professionally, it made sense. It may have been politically foolish because, you couldn't possibly win, and I didn't win the first time, but it was not because it was a shift. It was sort of like, look, if you want to be a power in this system and you want to really reform, you need to be a leader in a major office. And the district attorney's office, in terms of criminal justice, prevention versus prosecution and so on, was the powerful vehicle to do that. And so that made sense in terms of my career, not just my ideology.
Now, most people who run for district attorney serve first as assistant district attorney. Were you an assistant district attorney?
No, I'd been just the assistant attorney general. And so when I ran, one of the things I had to prove was I wasn't really just running as a defender. I mean, there's sort of this interesting controversies that have been going on now 50 years later about district attorneys who want to talk about being reformers and the concern that they're too liberal and that kind of thing. The argument that we made at the time was the same about how you attract good people, was to say to the police, look, this is about being tough on crime and smart on crime, not in terms of what your rhetoric is. And so with the better the lawyers are, the more those lawyers are trained and supervised, and the more they know how to handle and deal with the facts and the law, the more it will protect you as police officers as well as victims. And that was the pitch. And eventually, I really think that was what was accepted in a major way, that these offices, like the district attorney's office, should no longer be just political. And they may have had very good attorneys in them, but many of them were viewed as sort of political offices more than professional offices, because many people still had private practices. Here, you were bringing in people to be full-time professionals who were first and foremost adhere to a standard of excellence as lawyers. And it made a huge difference, I believe, in terms of the success of efforts to deal with crime, to deal with the police, to make the court system more responsive, and particularly to try to tell people that, for example, the district courts are where the Constitution is played out every day. And it's not in the academic world, but it's more here. And it's the district attorney that is leading the charge for civil rights and for upholding the rule of law, not just the public defenders and legal services attorneys.
Well, let's stay with that for just a couple minutes. First of all, what years were you district attorney?
I was district attorney from 1982 to 1990, 2 terms there. I had lost the first time to Mr. Droney, John Droney. John Kerry was the first assistant, you may recall, in Middlesex County at the time. I lost by 2% and then became general counsel of the State Ethics Commission, which had just been created. But then ran, and again in 1982, successfully, served for 2 terms there as district attorney, and then ran in 1990 for Attorney General of Massachusetts.
And won.
And won.
And won that election.
Right.
So staying just briefly on the DA's work, I mean, how, this is unfair to you because I'm asking you to answer this in a very short answer, but how were you able to affect the kind of change and advancement of civil rights as the chief prosecutor for Middlesex County?
I think, first of all, the campaigns made a huge difference. I think back on that I had a chance to sell myself all over the county for 4 years to some extent. I mean, one way or the other, so that they sort of knew who you were. But the second the pitch all the time was, we're making this a professional office, not a political office. And the reason it worked, I believe, aside from I had an action plan about what I wanted to do, how to do it, to be tough on crime and but smart about crime, and a number of things that we able to implement. But I was able to attract, because we're hiring on the merits and offering this experience, I was able to attract for $17,000 a year people like Ralph Martin, Jeff Locke, Tom Riley, Carmen Ortiz, Bob Cordy. I mean, the people you could attract by offering a job that on the merits, that you would be a professional first and foremost and not political, was a remarkable upgrading in the talent that you could get to be in these offices. So you had that, plus you then had experienced people there who didn't necessarily buy all this, but they'd been in the trenches for years, and they were able to serve as the experienced supervisors for all these young, charging idealists that we brought in. So you had this nice blend of very experienced people who will know, Bob Banks, John Murphy, people who'd been defenders and prosecutors for years, training and supervising these young, talented men and women of talent. And that made a huge difference in the office, the energy, the drive, and then the vision we had about making the office much more relevant throughout the county. I think the action plans I did made a big difference, even though people were tired of hearing me talk about it. But it was more the ability to attract and uphold standards that said, first and foremost, we are adhered to professional standards of excellence. We are first and foremost lawyers, not partisans, not activists, not reformers. But to be here, you have to be a good lawyer, first and foremost. And then other things follow from that.
I know some of the people you named, and they include somebody who later became district attorney and attorney general. Right. Tom Riley was attorney general.
It was also Martha Coakley. And Tom
Martha
Riley.
Coakley, attorney general, still practicing law. Carmen Ortiz was U.S. attorney. Bob Cordy became justice of the Supreme Court.
Margot Botsford, as well as
also a Supreme Judicial Court justice.
Ralph Martin became district attorney in Suffolk County.
So what a great training ground that must have been, and you attracted people of great character and ability, and they went on to do even more great work. So that's inspiring in the sense that good leadership produces good leaders. And you obviously had that in the DA's office. Now, and then you ran for attorney general. You became attorney general, served 2 terms as Massachusetts Attorney General in the 1990s. And, again, how did you envision using that position to further defend the Constitution and support the rule of law?
That was because of the powers of the Attorney General in Massachusetts, which is very broad. I mean, every state's a little bit different in terms of what the powers of the Attorney General are. But in Massachusetts, the Attorney General has broad jurisdiction. I mean, has the legal right to set the uniform legal policy of the Commonwealth. so that all the agencies and others have to sort of adhere to the Attorney General, criminal and civil. It sort of sits on top of this. It also had the benefit, Don, of having Frank Bellotti set this, establish this sort of idea that that's what the Attorney General was. It was actually why I won the office. The person I defeated was a very good friend of mine, Jim Shannon, who'd been a terrific congressman and had run for Attorney General, but had not yet made the shift from being congressman to being Attorney General. And so I ran against him, say, he practices politics, I practice law. That was my theme. I think he was a terrific guy. I supported him as a congressman. He continues to be an outstanding person. But in terms of the office, that was the defining characteristic. And so leading into that, that was an era then as Attorney General where we really were able to upgrade things on urban violence. We began a lot of the environmental efforts, major consumer protection areas, and eventually led to the tobacco settlement. I mean, the biggest case we had was the tobacco settlement, one of the first attorney general in the country to sue the tobacco companies. But it was also an era in attorneys general nationally that people had the model that was established was long gone now. But the idea was you were not a Republican attorney general or a Democratic attorney general. You were attorney general. And therefore, you worked together. So we had many multi-state bipartisan actions on consumer front, environmental front, and it sort of laid the groundwork for this monumental case against the tobacco companies, which were brought by Mike Moore out of Mississippi, Grant Woods, a Republican out of Arizona. I was Skip Humphrey and I were the next people in, and that led to the wonderful result of the tobacco companies being sued and dramatic changes. But it was also the example that was used in multi-level, smaller ways to show that if you're first and foremost a lawyer, if you're first and foremost, even as Attorney General, when you're suing companies, if they view you as suing them politically, it's one argument. If they view you because you're suing them because you believe in the facts and the law, they have violated that. That record tends to make a huge difference. The biggest change after that was after 1998 when we established the Democratic Attorneys General and the Republican Attorneys General. And led into the dilemma we have now, in my mind, with the legal profession of it being so partisan. At the time, it was a further proof to me that if you adhere to the principles of we are first and foremost lawyers, we'll make decisions on the facts and the law, we will not deal with politics, but rather what's right and what's wrong, and we represent people who without us have no one. We can attract better people to serve, we can be more effective in what we do, we can have a greater impact, and the public will accept it politically. It will also be good politics. That is, being the best professional, if you're a district attorney or attorney general, also is the best politics. It may not be the best politics for running for governor, but it was the best politics for being attorney general. And that impact nationally in the 90s was quite important for us in Massachusetts, but also nationally.
Well, that approach of following the facts and the law is a way you build trust. And I think it all comes down to trust. The reason it's good politics is people see that you're a trustworthy politician, that you are trustworthy in doing your job and fulfilling your oath and your responsibilities to the people that count on you to do that. So I hope that lesson still applies today. I think it may apply in some quarters and not in others, but it wasn't a loyalty oath, right? People weren't coming into the Attorney General's office and having to swear a loyalty oath to Scott Harshbarger. It was an oath to the Constitution of the United States and the Constitution of Massachusetts and the laws that are in effect. So, well, I think what we ought to do is skip ahead. I'll just briefly say that after your 2 terms as Attorney General, I understand you went back into private practice with a couple of firms. You're still senior counsel to one of those firms
Right.
now. And at the other firm, I understand you chaired their pro bono committee, which was another way you were trying to bring your values and service and the rule of law to bear on you and your firm, even though you were in private practice now instead of representing the public. Is that all fair? A fair summary?
Yes, I mean, I agree. We don't want to prolong this, but let's remember, I didn't return voluntarily to the public's private sector.
Right.
I mean, I ran for governor and lost by 2% in 1998
to the incumbent.
And Paul Cellucci, and the point about that was a period, and it's interesting compared to today. In that period, 41 attorneys general ran for higher office, and only 2 won, because they could have continued as attorneys general, but when they sought to be senator or governor, the standards were different. And as somebody said, you're one thing if you're attorney general, but if you've sued everybody in the state and you're now a governor and you're running for governor and you ask them to support you, it doesn't always compute how to work on that. But the point about that was I then had the opportunity to go to Common Cause at a time when John McCain and
oh, that's right. I left that out. Yeah, that's important.
Others were trying to pass the campaign finance bills. I got to meet John Gardner, an incredibly important person in my life. At the time, he'd been the former founder of Common Cause. And then when I came back to practice, I was able to build a governance practice based on independent investigations and that kind of thing. And when I went to Proskauer, I'm fast forwarding only because the head of the firm at the time simply asked if I would mind chairing the firm's pro bono initiative, which was, of course, a great benefit to me in many, many, many ways. But it also gave me the chance to see how the change had occurred in the legal profession. That is, you could begin to see that the big law firms were focusing much more on being a business as opposed, yes, they were letting people do pro bono work, but in terms of the public image, you could begin to feel that it wasn't going to be quite the same if the need was for these firms to step up and lead. And unfortunately, that's what I've seen in this era where you'd like to see the law firms playing a lead role and haven't.
Well, I understand that. And let me just comment briefly on that. I mean, but this could be a whole other episode of the podcast, so we won't dwell on it too much. But it is an important point. I started practicing law after I finished my judicial clerkship in 1980. The 1980s were the time when everything started changing. And some people would say that one of the catalysts for that change was the publication of The American Lawyer, which was a new magazine that came, magazine's probably a poor word, a new publication for the legal profession. And I believe that it was The American Lawyer that began measuring profits per partner and comparing law firms by how profitable they were for each partner on average in their law firms, which is still the measurement, one of the measurements that's used today. And once that started happening, firms began to compete, especially the big firms, with each other in terms of can we go up the rankings in The American Lawyer to show that we're making more money per partner than other firms, and therefore we're going to attract more people who are also going to help us make more money because we're competing for talent, we're competing for clients. And one way to really show that we are an important, prestigious firm that's going to attract lawyers and clients is showing that we are high in the rankings based on the profits we make per partner. I think I'm not the only one. I think that a lot of people have suggested over the years that really changed the culture of a lot of large law firms where the priority was all on revenue and profit. And while they still tried to balance some of that out with pro bono and other public service, some law firms were better at that than others. I will say, having said all of that, I don't want to sell law firms short. I think many of them still have very important pro bono initiatives. Many of them are still public oriented. Some of the firms you named earlier are in that category, I believe. But that doesn't mean that they're not also paying a very close attention to the bottom line, and that drives a lot of what happens within these law firms.
I think that's absolutely correct, Don. And that period, by the way, in the 80s, it also benefited us in the public sector because many associates who either couldn't compete or didn't want to compete in that system started looking to the public sector as a vehicle. And once we could get them there, I think the combination of the quality of the work and that kind of thing, they would stay. That was the biggest benefit that happened. These very talented lawyers who started at law firms then come to the public sector and see, aha, we can be lawyers. We're maybe not making as much money, but we're having more impact, learning more. Made a huge difference for the public sector. But it was exactly that break that you began to see when I went to Proskauer, which was a great firm, and it was a wonderful opportunity to be head of the pro bono initiative. But you could see, and when we later started Lawyers Defending American Democracy, many of the then managers of these firms said, you could not today, which is true, we learned, you can't get these heads of firms to do some of the things that you got them to do in the 70s and the 80s. That's just not the dynamic that's going to work with the law firms.
You told me when we were preparing for the podcast about what happened when you attended your 50th law school reunion at Harvard Law School, which
was
what
1968.
Year?
No, well, 1918.
So it was 2018.
2018. Right, my 50th reunion.
Okay.
And
so tell us that story.
Well, Harvard, you write this, you have a chance to write this thing for the Red Book in advance about your thoughts about whatever their thoughts are. And my thoughts at the time, 2018 have been 2 years into the Trump presidency. And my point at the time was to say that I had been shocked by the stunning silence of the legal profession, given the obviously very public assault that President Trump and his enablers had made on the rule of law, the Constitution, and core democracy norms, values, and principles. And had some examples of them. But basically, I said I did not think this was a partisan issue, that I thought this was about being a lawyer and the lawyer's responsibility to stand up to preserve and protect the rule of law, and that we should be off the sidelines and in the fray. And the fact that so many were not in the law firms had been so quiet, deans of law schools, bar associations, and heads of law firms had simply been silent on this, including many of my former colleagues as former attorneys general who were in law firms now, who had been very vocal before, were simply letting this happen. And that I couldn't understand why somebody would say this was Democrat or Republican, because I didn't think that the principles of equal justice, equal protection, fairness, and that kind of thing were partisan issues. It triggered a lot of discussion, and I also had a speech I gave at the reunion as well that triggered a lot of interest by my reunion classmates. And from that, we decided that we should try to form an organization that would try to articulate core principles that we thought lawyers should be adhering to in a nonpartisan way, that they weren't political issues, they were nonpartisan issues. And it came to be, that's how we formed Lawyers Defending American Democracy, and really in the beginning of 2019. But it was also intriguing to me at the time because so many other lawyers who agreed with that, but did not join. And that should have been the first warning cry to me in a way as, wait a minute, if you can't even get people who agree with you who are retired as lawyers because they do not want to be perceived as political or partisan, and they aren't, for whatever reason, they are not seeing this as being the kind of challenge to the core principles of our democracy and the rule of law that we saw. That that was the surprise. That should have been the surprise to me. That should have been, whoa, because we thought naively that once we put out these core principles, and they were sort of the obvious ones, like truthfulness in public officials, elections should be fair, that you shouldn't, the separation of powers, respect for the voting process. I mean, core principles that we all agreed with. And yes, many people signed on with us, but simply otherwise were silent. And that has continued, and that continued then. But that was the reason we formed Lawyers Defending American Democracy.
So you say we formed. So who was working with you on this when you started?
My classmate Gary Ratner had really been one of the leaders in mobilizing this. People like Nick Fells and others. And then when we joined, I asked John Montgomery, former managing partner Ropes and Gray, had been a first assistant attorney general, Jim McHugh, who I'd gotten to know, work with on probation commission, and then was the appeals court judge and many things, and eventually Lauren McLean and a core of really, really well-known, respected lawyers in law firms and elsewhere, and sort of joined with this in this effort to try to get, and the goal was to galvanize and mobilize the legal profession, figuring that, look, the problem wasn't that they didn't care, we sort of thought, maybe naively. You might join the ACLU, you might be active in many other ways, but this needed to be a nonpartisan effort, because the assault was framed so much in partisan terms. That is, if you supported the Constitution, you were a Democrat, as opposed to being, wait a minute, I am first and foremost a lawyer, a citizen. What then became clear was that people were unwilling to be out in the fray. They saw this as being political. Everything that was become political, as opposed to being about core principles. And of course, then with the January 2021, where public officials, lawyers taking the oath of office, refused to certify the election, you began to see the whole thing unraveling. And we not only didn't stop it, it has, in my view, metastasized now. And what makes this upcoming election such a real existential moment, and I hope, I'm still hoping that the legal lawyers, the legal profession, will assume the role of being the protector and defender that it was, in my mind, in the late 60s and early 70s, and should be today. But that's the challenge, Don. That's the challenge we face, although it's been a very, very rich experience to be a part of this group at the Lawyers Defending American Democracy, to get the response we've gotten, which is from people who really are grateful that there's a voice that is this nonpartisan voice speaking and trying to do things like assure that the rules of professional responsibility apply to lawyers as well as others.
So let me just ask you a couple questions about this. I mean, first of all, you named a few of the people who have been working with you on this, and I know them all to be Massachusetts lawyers, but this is a national organization now, isn't it?
Yes, it is. And we have people, Martha Barnett from Florida, Peggy Quince, a former justice of the Supreme Court in Florida, Estelle Rogers, who's in California, who was a major player in D.C. for years on legal services issues, Evan Falchek. I guess I can name all 12 of the current members of the board. But what we wanted to do was to try to move it beyond just being Harvard Law School alums and recruiting people who just have added so much to it. I mean, otherwise you just have lawyers talking to each other, but people like Lauren McLean and Dennis Afrigot have made a huge difference in terms of having us reach out, think about what our platform is, what we're trying to achieve, how we can involve more people. But we also specifically with people with these lawyers like Montgomery and McHugh and Ratner and Fels focus on things like the discipline efforts we made about Giuliani, about Eastman, about Chesborough, and Jeffrey Clark and others, where we have sought to maintain that they have so exceeded the bounds of acceptable professional responsibility conduct that they should be disciplined by the bar. And if we're not going to do it, who is going to do it? It's not just about the law, it's about upholding the ethical standards of the profession. And if you don't do this now, how do you teach ethics in law school to the next generation of lawyers?
And how do you have a rule of law
Right.
if you don't defend the ethical requirements of lawyering? Let me just, after we talked the other day, I sort of had an idea of an analogy on the partisanship issue. I don't know if it works or not, but I'll just throw it out there. You know, we've talked a little bit about the Vietnam War and the anti-war movement. It strikes me that was a cause. It was a movement directed at a war, at a cause, and stopping a war. That war was being waged at first under a Democratic administration. LBJ was president. And we all remember the chants, right? Hey, hey, LBJ,
Right.
how many kids have you killed today? And then Nixon inherited it when he became president. And the movement continued. It was the same movement. I suppose the same is true of the civil rights movement, but I'm really thinking more about the anti-war movement. It just was who happens to be doing what we're opposed to at the time, not what party do they belong to. And I think that's kind of what you're saying, that we're focused on, we being lawyers, but mostly we're talking about LDAD right now. LDAD is focused on defending the rule of law, bringing ethics complaints against lawyers who are violating the rule of law and violating professional ethics in order to advance, in order to seize power and gain power and hold power. But it's not that you're after Republicans. It's that you're trying to go after or pursue claims against the people who happen to be doing the thing that you're opposed to. It's the thing that matters, not the people. Am I off base on that?
No, I mean, I think this was one of the things that bothers everybody. That is, why does it appear that you're just criticizing Trump and Trump's enablers? I mean, you call it whatever you want, the former president, the candidate, and others. And what you're saying is, but the answer is you're not doing that. Here in our history, no president or candidate has tried to challenge the results of the peaceful transfer of power. It simply hasn't been done. No president or party has claimed that the biggest problem is the enemy within as opposed to the external enemy. Nobody in any other party has used the vehicle of claiming that the norms and values of our democracy, the sense of integrity, of truthfulness, and the appreciation for the value of the separation of powers, have used it as a vehicle to eliminate those because they can't be enforced by law, but are required to be enforced by conduct. So what you've had here is a period which some has chosen to shatter it. I mean, to some extent, instinctively, politically, you'd say this is a genius effort on that part. But what it requires are those of us that are charged with the responsibility, I believe, to uphold the rule of law, to stand and deliver on behalf of the constraints that keep us free, have to have an equal reply. And that can't be done in a partisan manner. Because what you're seeing now is it's being treated as, well, they say this, the other side, what do you say on this side? Instead of it being the American Bar Association's position, the leaders of big law firms, the deans of law schools, and young lawyers being taught now that your responsibility is to the profession and to the quality of justice, not to partisanship. If you're going to take this oath of office, if you don't want to do that, fine, but you can't be silent about this. And the trouble that we have today, in my view, is that the models that we're giving to people are primarily activist, partisan models. And I'm a Democrat. Yes, I probably support that as a partisan matter. But I know that as a lawyer, as a district attorney, as an attorney general, to the extent that I was successful, it was because, yes, I had good ideas and an action plan, but I was able to attract people to convince them that we are first and foremost lawyers determined to uphold a standard of excellence, the oath of office, be trustworthy and fair, and adhere to the core principles and values. That's what made us good at what we did, and that's what preserved the integrity of the system.
If it were a Democratic president or a Democratic candidate for president or Democratic legislators doing what the former president has done, you would be challenging them the same way you're challenging this person.
Yes. I mean,
that has to be the principle.
No, that's exactly right. And I think that we have not been able to show that because it's been so dominant in terms of the continuing conduct. And I believe the conduct continues, Don, because there has not been an effort, not just to hold him accountable on the law, which is what, as my dad said, was the way we define things. It's not just whether you are or not a crook. Is the conduct that you are doing consistent with the rule of law and the Constitution? And there's plenty of room to agree and disagree about that. But when you cross the line, when you sort of simply lie, and as lawyers present fraudulent information in court, that is a violation of the core principles of law. And if you're supporting a system that people are doing that, and you know they're doing that, then that needs to be called out and held accountable.
And I think it's important to clarify that LDAT is not just focused on former President Trump. You're focused on any serious threats to the rule of law and democracy, no matter who is bringing them. Right. And some of the work you've done has been with respect to people in positions of power. I'm thinking of the Attorney General of Texas, for example, right? Who are not part of a Trump administration or not part of a Trump campaign, but who have done things that you believe, your organization believes, violate rules of ethics. Well, let's talk about LDAT. Yeah. Oh, go ahead. No, you want to finish that up?
Because I think the other thing is that our role that I see, and maybe this is where you're going with it, is the educational piece. What I think I was surprised about is how many lawyers, and therefore how many citizens, simply either don't accept or don't know these are the core principles, that these are norms and values that shape our profession. Now, I could be wrong. Maybe I'm overdoing it. That is to assume that. But I think this. I guess I've always believed that these oaths have some degree of accountability and responsibility to them. That's what you've chosen to do. And it's not just only representing a client zealously within the bounds of the law, but it is that you have accept these propositions. And one of our jobs clearly is to try to find a way to educate, to convince, and slowly I look at Judge Ludwig's efforts. I look at now the new ABA efforts. Yes, we're beginning to see the organized bar and leaders of the organized bar step up and say, we have got to be stronger in educating people about what democracy means, what the core principles are, why why these norms and values matter
Right.
to
You know,
the
and
country.
there's a lot of good stuff written about this. I just read Timothy Snyder's new book on freedom,
Right,
and he says these values matter because without them we're not free.
right.
And it's a brilliant book, although I will say it's a little challenging of a read, but it's still a brilliant book. So let's talk about Eldad. We've been going for a while, and I want to try to make sure we get there. Your group from your Harvard Law School reunion decided to get together and form this new organization. And I think from some of your answers already, we sort of have the sense. What I was thinking too was, well, why form a new organization? Why not just work with one that already exists? What about Common Cause? But of course, Common Cause is not strictly a lawyers' organization. LDAD is focused on lawyers and the role of lawyers. Why not the bar associations? Well, I think you just got ahead of the bar associations, and they're starting to catch up. The ABA has been catching up, especially under the leadership of its past president, Mary
Right.
Smith. We'll talk about that a little bit. But I just want to read to you what's on your website about the mission of Lawyers Defending American Democracy. And you've actually used some of this language already today. The mission of Lawyers Defending American Democracy is to galvanize lawyers to defend the rule of law in the face of an unprecedented threat to American democracy. Our work is not political or partisan. We unite members of the legal profession in enforcing and upholding principles of democracy and law consistent with our obligations as lawyers, demanding accountability from lawyers and public officials, and calling out attacks on legal norms and prescribing redress. We've already talked about that first section about what the mission generally is. Maybe what we could do now is talk about what is the work of LDAD? What has LDAD been doing? I did do an episode with Lauren Rickling, and she explained some of it, but we also, with her, just like with you, I covered her biography a little bit. So that was only a part of what we talked about, but maybe you can expand on it a little bit. Tell us what LDAD has been doing and how well it's going.
Well, I think there's other people have to judge how well it's going. To me, the keys of what we've been trying to do and what appears to be our role is that we are trying very hard to stay focused on not being partisan, but focusing on legal principles. We try to identify lawyers who have gone way beyond the bounds of the ethical principles in terms of representing or asserting fraudulently attacks on the system. But more importantly, I think now it's more and more trying to educate lawyers themselves and citizens about what they can do as lawyers. And to some extent, it's also reminding people what their oaths of office are and what they have sort of committed to do. What we are not doing, and which is, I think, important for us, is we are trying not to be in the space of partisan attacks on any candidate. As we said to some people, the trouble right now is that the candidate, the party that is attacking this openly, systematically, happens to be the candidate and the party of former President Trump, and they are doing this. So therefore, it has to be called out. We cannot be silent, because that reminds people, as the Timothy Snyder has written before, and others, and Ann Applebaum does in Autocracy, of taking you back to the 1930s, to Germany, where people did not want to take a position against.
Right.
This is requiring people to take a position. That is to say that these are core principles that have to be adhered to. I am still concerned, and I think one of our focuses on this education and ethical issue of young lawyers and other lawyers. I do not understand why, and maybe I am not hearing it from people. I hear from many, many lawyers who simply do not believe that they have a responsibility to speak out now or speak out on these issues, that to do so is political and partisan. And if they do that, it's sort of affects their clients on the one hand, or simply involves them in a way that they don't want to be involved. And that to me reflects the missing ingredient that somehow in the 60s, I know this is 60s rhetoric, we were imbued with as lawyers. I mean, at least there, when people agreed or disagreed that we should be activists, but they were clearly engaged. They clearly were engaged. They understood what was at stake. They may have thought they didn't need to do anything about it, or they thought they did need to do something about it. Today, what we now see are that most people who are going to do something do choose a side, so that you know, if you're an activist, you may want to be active with the ACLU or with Common Cause or with Protect Democracy or some other group, or on the other side with the Heritage Foundation or the Republican Party. No one sits in the middle. And to some extent, we are trying to sit in the middle and sort of say to people, here is what the contest is about. It's about who and how do we protect and preserve these norms and values, and not just have it all depend on the law or criminal prosecutions. How do you ensure that a Justice Department remains independent? How do you ensure that the Supreme Court adheres to the ethical rules? How do you ensure that attorneys general in states around the country stand up for the principles of their oaths of office, or are engaged in partisan activity on behalf? That is, how do you handle lawyers who are representing clients legitimately, or others who know that their clients are actively engaged in the process of trying to subvert the rule of law, and they are still supporting them and actually encouraging them to do this? Again, that's what's new. It seems to me obvious, but on the other hand, Don, it's very clear that our job will continue to be to try to keep educating people, be a vehicle for people who want to try to understand this. Maybe they want to criticize us, maybe they want to support us, but to try to be here to sort of figure out how do we as lawyers in a time of crisis for our democracy and the rule of law, which I fear will be even more of a crisis after November 5 and the challenges, how do we play a role that I believe is central to having the privilege of being a lawyer? And the privilege does not include sitting on the sideline and simply cheering on others or supporting partisan activist organizations. We must find a way to have deans of law schools, heads of law firms, heads of bar associations feel that they can responsibly take leadership roles in articulating the ethical obligations of lawyers in a time of challenge to the core principles of democracy.
Boy, that's really well said, Scott. And that's such an important job. And let me just add this. There are other things that are going on with other organizations that LDAT actually is supporting. For example, there's an organization called the Society for the Rule of Law that has a statement of principles to preserve, protect, and defend the Constitution, which has been adopted by the American Bar Association and promoted on your website, the LDAT website. There are Mary Smith, president of the ABA last year, when her very first act, I believe, was to form this task force on democracy and the rule of law, which was headed up by Judge Ludwig, a Republican, a conservative judge, and co-chaired by Jay Johnson, who served for a period of time as, I believe, Secretary of Homeland Security. So, and they've come out with a report that also lays out a number of things lawyers can be doing to support the rule of law. I think all of that is available on your website, and I would encourage people to go to it who are interested in getting involved in some way or other to defend our democracy and defend the rule of law, even after this election, no matter how it comes out. So thank you to you. Thank you to Lauren Rickling. Thank you to all of your colleagues who are doing this very important work. I know it'll make a difference. How much of a difference and how long it takes, who knows? But I think what you're doing is making a very important difference, and it's important that you keep it up. So, Scott, thank you so much for appearing. This has been a great pleasure and privilege to speak with you, and I know our listeners will enjoy hearing from you too. So thank you very much.
Thank you, Don. Thank you, and good luck in editing. I appreciate it. Thank you.
Will do.
This has been an episode of Higher Callings. Your host is Donald Federico. Music is provided by Fancy Mountain, and our logo was designed by Matt Pedro. The associate producer is Brian Federico. Higher Callings is a production of Federico Media, LLC.